Explain various kinds of writs provided under Constitution of India. Introduction. Writs are the soul of justice. Under Article 32 and 226, they protect citizens from injustice, safeguard fundamental rights, restore dignity. It ensures authorities act within law, preventing misuse of power and uphold fairness. Repetition. Writs are the soul of Constitution. Under Article 32 and 226, they protect citizens from injustice, safeguard fundamental rights, restore dignity. It ensures authorities act within law, preventing misuse of power and uphold fairness. First main heading. There are a total of 5 points here. So first main heading, 5 types of writs. First one, habeas corpus. That is, you must have the body. First point, it protects individual liberty against illegal detention. Second point, that is case law 1. In Preeti Yadav vs. State of Uttar Pradesh 2025, court allowed habeas corpus petition and ordered release of the husband from illegal police detention. Exception. Lawful and emergency detention may limit writs. A repetition of first main heading, that is 5 types of writs. First one, habeas corpus. You must have the body. First point, it protects individual liberty against illegal detention. Second, that is case law 1. In Preeti Yadav vs. State of Uttar Pradesh 2025, court allowed habeas corpus petition and ordered release of the husband from illegal police detention. Exception, lawful emergency detention may limit writs. Second point, there are 5. In second point, there are again 5 points here. Second point, mandamus v. command. First point, it forces public authorities to do their legal duties. Second point, it can't be used against private people, the president, governor, or judges. Third point, that is example, public servant not granting pension, court can direct payment. Fourth point, that is case law 2. In Harish Chandra Tewari 1981, mandamus directed board to issue duplicate mark sheet promptly. Point number 5, discretion. Courts may refuse if duty is discretionary, not mandatory. Repetition of point number 2, that is mandamus v. command. There are 5 points here. First one, it forces public authorities to do their legal duties. Second point, it can't be used against private people, the president, governor, or judges. Third point, example, public servant not granting pension, where court can direct payment. Fourth point, that is case law 2. In Harish Chandra Tewari 1981, mandamus directed board to issue duplicate mark sheets promptly. Point 5, discretion. Courts may refuse if duty is discretionary, not mandatory. Third point, that is certiorari, to be certified. There are 3 points here. First one, quashes illegal orders to lower courts / tribunals, preventing violation of natural justice. Second point, that is example, tribunal deciding cases without hearing parties violates natural justice and it can be quashed. Third point, that is case law 3. In Ram Kumar vs. State of Uttar Pradesh 2023, certiorari cancelled an arbitrary transfer order made without following proper legal procedure. Repetition of point number 3, that is certiorari, to be certified. Point number 1, quashes illegal order of lower courts, tribunals, preventing violation of natural justice. Point number 2, that is example, tribunal deciding cases without hearing parties violates natural justice and it can be quashed. Third point, case law 3. In Ramkumar vs. State of Uttar Pradesh 2023, certiorari cancelled an arbitrary transfer order made without following proper legal procedure. Next is prohibition, to forbid. There are 3 points here. First one, prevents lower courts, tribunals from exceeding jurisdiction. Second point, that is example, court attempting to hear a case outside its legal authority. Point number 3, that is case law 4. In East India Commercial Company vs. Collector of Customs 1962, the court stopped such overreach. Repetition of point number 4, that is prohibition. First point, prevents lower courts, tribunals from exceeding jurisdiction. Second point, example, court attempting to hear a case outside its legal authority. Third point, that is case law 4. In East India Commercial Company vs. Collector of Custom 1962, the court stopped such overreach. Point number 5, quo warranto. that is, by what authority? There are 4 points here. First one, challenges if someone is illegally holding a public office. Second, any citizen can file it to stop illegal office holders. Point number 3, example, a person wrongly occupying a government post. Point number 4, case law 5. In Vinith Narayan 1998, the post must legally exit and the person must have a lawful right to hold it. Second main heading, that is emergencies. There are 2 points here. First one, even during emergencies, writ set limits on government power. Point number 2, it protects citizens' rights from arbitrary state actions. Repetition of second main heading, that is emergencies. 2 points. First one, even during emergencies, writ set limits on government power. Second, it protects citizens' rights from arbitrary state action. Third main heading, that is awareness. You have 4 points here. First one, it helps citizens recognize when their rights are being violated. Point number 2, it encourages citizens to take part in governance. Point number 3, it strengthens accountability in government actions. Point number 4, it promotes rule of law. Repetition of third point, third main heading, that is awareness. There are 4 points here. First one, it helps citizens recognize when their rights are being violated. Second point, it encourages citizens to take part in governance. Third, it strengthens accountability in government actions. Fourth, it promotes rule of law. Fourth main heading, that is critical analysis. There are 3 points here. First one, though writs protect people's right, delays in courts and lack of public awareness reduce their effectiveness. Hence, courts must protect citizens while respecting governmental space to protect writs effectively. Fourth main heading, that is critical analysis. Though writs protect people's rights, delay in courts and lack of public awareness reduce their effectiveness. Hence, courts must protect citizens while respecting governmental space to keep writs effective. Fifth main heading, that is comparison of writ with different countries. There are 3. First one, in India, writs directly protect fundamental rights. Second, in UK, judicial review is limited. Third, in USA, constitutional remedies exist but involve lengthy procedure. Repetition of fifth main heading, that is comparison of writ with different countries. There are 3 points. First, in India, writs directly protect fundamental rights. Second, in UK, judicial review is limited. Third, in the USA, constitutional remedies exist but involve lengthy procedures. In conclusion, there are 2 points. Writs are guardians of liberty, turning law into hope, protecting fundamental rights. Point number 2, it ensures fairness and gives citizens the strength to challenge injustice while restoring balance and accountability. Repetition of conclusion. Writs are guardians of liberty, turning law into hope, protecting fundamental rights. It ensures fairness and gives citizens strength to challenge injustice while restoring balance and accountability.